that on, Ted?
It is, sir. You may
All right,
proceed.
we are back at 7:35. We've just come back from executive session, and we are prepared to hear the appeal filed by Du Bois Livestock, Inc. Ricky, are you going to be the person, or is there someone else? All right, let me just put on the record some things that I think are important, and correct me if I'm wrong with this information. The appeal is of a letter of notice of violation dated October 30, 2012, from the Code Enforcement Officer to Du Bois Livestock, Inc. I have a copy of that, as is required as part of the appellate process. I also have proof that the appellate fee of $250 was paid, so thank you for that. That's also required. I also have proof of ownership of the relevant property, so you've met all those requirements. So just want that on the record, that you have satisfied the three requirements that you have to have to move forward with the appeal. And I know you said your name earlier, is it Saul?
Saul, better.
Okay, so can I just ask a question before you start? May I call you Saul?
Sure.
And so you can stand, you can sit, whatever your preference is, but are you a member of the corporation?
Oh, yes, I am. I'm a director, and I'm also an officer. I'm the secretary.
Okay, and just again, so we have a good record here, when did you become a member and an officer?
Oh, 7 years ago.
Okay. Right, and are you here in a capacity as an attorney as well, or no?
Nope, just as a member of the officers or the.
Of Du Bois Livestock, Inc.
I'm also a trustee of the Randy Trust. I think I should set something straight. The Randy and Ricky are not the trustees of that trust. They don't run it or and don't have any part of it in that particular regard.
Yeah. And since I put on the record before you start all documents that we received, I want to make sure you received, meaning the corporation received a legal memo, I'll call it a legal memo, that was drafted on behalf of the Code Enforcement Officer from Bill Dale. We have that. Did you receive a copy of that as well?
Yes, we did.
All right, I just want to make sure you have it.
Did you also receive our statement of appeal?
Yes, so we've got the statement of appeal, which I think was called Attachment A, right? That's what you're referring to?
Right.
It's,
You should also
3 pages tight.
Yes, you should have also got some correspondence, the State of Maine Department of Agriculture.
Yes, yes, as attachments, so let's put that on the record. July 19, 2001, from the State of Maine Department of Agriculture, a letter to Randy Du Bois at Du Bois Livestock, Inc. Another letter dated December 13, 2011, State of Maine Department of Environmental Protection to Randy as well. Those are 2 letters you're referring to?
Yes, I am.
All right, good.
Yeah, I should say something, go through my stuff. Ladies and gentlemen, the first thing I would point out is that they are correct in the sense that we did apply for a conditional use permit from the town of Arundel, okay? And that particular permit was, in our eyes, okay, and I believe in the eyes of the planning board, was issued based on the fact that we were performing a non-conforming commercial solid waste use of the composting property. Now, this entire process of acquiring this particular license took about 1.5 years, okay? And it dealt greatly with the issue of the understanding by the planning board that we were a non-conforming use in an agricultural setting, okay? We're in, I believe, the C4 district where agriculture is in essence king. That's where you do it. After the hearing, and we felt compelled to make inquiry into whether or not we were actually a non-conforming use or a truly conforming use under the laws of the state of Maine. And in doing that, we acquired the 2 letters that we produced to the appeals board. The correspondence And I would like to direct you to, at least a portion of it, is on the first letter dated July 19, 2011. It states, the composting of these materials on a farm meets the department definition of an agricultural composting operation as described in Title 7, 152, Maine Agricultural Protection Act. This was also confirmed by the Department of Environmental Protection on December 13, 2011, where they also indicated, based on determination by DAFRR that your operation meets the definition of a farm, and based on the materials licensed for composting by Department Code S021843-CG-A-N, your composting facility meets the definition of an agricultural composting operation as defined in 06-096 CMR 400. All those numbers actually mean something to us because that's our license. Okay? That's the license that we compost under the DEP. Okay. It was determined by those letters that we were a agricultural, okay, composting operation, okay, which is a farm, okay, and we were also at the same time determined to be under the Maine Act that protects the farms, and we did everything we could, okay, to establish that our composting operation was in essence exempt from activities in relation to the town's ordinances when it comes to composting. Now, the reason for that was not to avoid any type of regulation. Okay, we are completely regulated by the Department of Agriculture, and we're even more regulated by the Department of Environmental Protection. Okay, these guys, for instance, if anyone complains by statute about any type of thing that's leading to the farm, to the Department of Agriculture, immediately, okay, someone must come out and investigate. There's no questions asked, they investigate. They show up and they investigate. And DEP, there's no difference. Okay? So, what occurred in relation to this particular matter, we went along and just, contacted the town, sent them the letters, indicating that we had in fact met the standard and we were a farming and an agricultural composting operation. In or about, in about February 10th, 2012, a little after that, we received a letter from, I believe it was the code enforcement officer and the town planner, Ted Redway, indicating that, and I'll just read exactly what they indicated, okay? We also acknowledge that you have solicited and received letters of confirmation from both the Maine Department of Agriculture and the Maine Department of Environmental Protection, confirming that your composting operation would be considered by those agencies to be an agriculture activity. The next paragraph, however, they say, from the onset, please be advised that although we always appreciate hearing from our counterparts in the state agencies, the fact remains that the police power for regulation of land use activities within the municipal boundaries of Arundel are and remain within the sole jurisdiction of the town of Arundel as granted in the state of Maine in 30-A MRSA sections 3001 to 3006 and sections 4351 and 4352.
So, may I interrupt for a second? Whatever you're reading from, I don't think we have a copy of that. Do we have a copy of that we're reading from?
You know what, you may not. I scribble all over, I can certainly get you guys copies of it.
Yeah, I'd appreciate it. If you're going to read it into the record, I'd like the record to really be sufficient. So if there's
The town has it here.
If you could just cite the date of the letter and
well,
how
we as a
much
board don't have it, so that's my question. And so I see that you wrote your notes on it. I'm not trying to see your personal notes.
Oh, no, it's just,
I just want a clean copy if you have it.
I mean, the personal notes just,
And if you don't, if you just would say it again, I think you said it earlier, but you said it fast, what the date of it is,
the date is February 10th, 2012.
and it's from the CEO?
Yeah. CEO and signed by the Ted Redway and Tim Nagel.
Okay, so signed by both the town planner and the CEO,
Right.
and drafted to Livestock Inc.?
To Randy Woods, President,
Okay.
Voice Livestock Inc.
And your best understanding is that a copy of that is somewhere within the town records?
Oh, yes, yes, and we'll get your copy of it as well.
All right, good, I just wanted to.
Mr. Chairman, can you give me the date again? Because I might have a clean copy I can give you.
February 12th, 2010, 12? Oh, excuse me, February 10th, 2012.
February 10 or
10.
February 5?
And this is from right here.
All right, is that the thing for this one? This is February 5. Looks like almost exactly the same as this one. Does yours look like on the third page? Is that what yours looks like on the third page?
Sticking together. Got it. Mine's different.
Yeah.
I got the whole signed deal, huh?
I think it's the same letter, but he's got the signature.
Yeah, he's got the
back.
certificate.
Are these the same, the substance, do not? This is February 5 and this is 5 days late. Mr. Chairman, you give us a second, we might have a clean copy for you.
No, definitely not.
They also attached a letter from Nova Castle in the back.
From Nova?
Yeah, there's that little letter. I think it was attached to it. Yeah, I saw
Let's
it.
do this one.
No, I
Yeah,
think
these
it
two
is.
letters are the same.
You're right, so it was attached to the back of the letter.
This says. Mr. Chairman, if it's any help, we have a clean copy of the letter he's talking about. Ours is dated February 5, apparently 5 days later that you typed it and signed it, but otherwise it's the same. That's helpful.
That would be helpful, Tim.
It's just you can, and I can get another one from Jim.
Thank you. Thank you. And you agree, Saul, that the February 5 is the same letter, just unsigned, different date?
Different dates, different date unsigned, yes.
But same letter?
Same.
Okay, thanks.
Also attached to the letter was a correspondence from dated September 7th, 2010 from Bill Kastner. One of the important things about the attachment letter, which was important to us, was the fact that it demonstrated that when we were seeking our permit, that we were getting a non-conforming type of a permit, okay, which is very important to us in the sense that, you know, we really felt that we were not. But in the confines of her letter, which is dated September 7th, 2010, again, since the current operation has been determined to be a non-conforming use, it cannot be expanded beyond the original approval. And we were in the throes of figuring out the actual boundaries of the composting area that it actually existed. So I would like to leave you at least, I got a copy of those letters, that part marked if you like a copy.
Sure, thanks.
Go.
Thank you.
There's some more for you.
Yeah, that's great.
Now, to make a long story short, okay, when it came right down to our contentions in relation to our non-compliance with the two particular requests of the CEO, we were harbored the well-founded belief that because of the fact that we were determined to be a agricultural composting facility or operation and not a non-conforming type of a operation by the state of Maine and two of its departments, we were obligated at that point to comply with a statute that, or an ordinance that was opposite as to what we were actually supposed to follow.
And don't let me put words in your mouth, so you tell me if you agree. Does that mean, Saul, you're basically making a preemption argument to us?
Yes.
So you're suggesting to the board that this board may have jurisdiction in your mind to rule on a preemption issue?
Yes.
I'm not sure if you're right about that. I don't know if this board has that authority, but okay, we'll listen to it.
And if, and within the correspondence that I sent, okay, or we sent, there is a particular section in statute, okay, that it's the Maine Agricultural Protection Act, that particularly Title 7, Maine Revised Statute, annotated 154, and it provides, in very relevant part, a method of operation used by a farm or farm operation located in an area where agricultural activities are permitted may not be considered a violation of a municipal ordinance if the method of operation constitutes best management practices. Now, that's pretty solid, okay? And that particular letter that we produced is a very clear reason why, okay, there is a preemption. Okay, there's no question that the statute, okay, that protects agriculture and protects farms, okay, would be absolutely absurd, okay, and defeat if the state of Maine was incapable of determining what was agriculture, what an agricultural operation was, and whether or not it was a farming operation.
Does that statute, though, Saul, cite to you anywhere that you can, or read to you anywhere you can cite to us, that gives a zoning board of appeals in a municipality the power or authority to issue a ruling on a preemption argument?
Well, see, that's very interesting, because what it does is it's not just preemption. We're talking about an issue involving whether or not, you know, an ordinance, okay, can be validly applied, okay, in a situation where a farm is in existence, okay, and in this particular case, we do have a farm that's in existence determined by the state to be such, okay. We're not saying that you should say, well, this one preempts it. What it is you should be able to say that the issuance of the violation was not valid based on the fact that there is a statute that does not permit an ordinance to be, you know, perfected in this particular circumstance.
Can I ask you a question? Mr. Chairman.
Oh, absolutely, sorry.
So with respect to section 154 in Title 7, can't you really read that section to say that the ordinance, that the municipality can't somehow regulate the nuisance itself? Isn't that really more of an issue of trying to regulate the nuisance and not the operation of the plant?
Well, I believe that in the sense of nuisance, they intend to include all of that particular area. Because anything that would be involved where the town would have an issue is a nuisance. Okay, 9% of the DEP licensing is going through and making sure that there's no smell, there's no leakage into the water.
Right.
And I mean, it's very extensive.
But you can see that section 153 talks about nuisances and the way that the state, municipal, and federal law regulates it, correct?
Oh, I believe it does talk about this, but it also indicates that it is intended for this particular statute and body of law to be able to meet the legislative intent. Okay, municipalities cannot, okay, interfere with the farm's operation when they're using their best management practices.
And who determines the best management practice?
The Department of Environmental Protection and Department of Ag. And they're very critical of it. They're very critical. Now, I really don't have very much more, ladies and gentlemen. I think that's probably the primary essence of my presentation. I would, however, add that we did raise the issue that had the what do they call it, the people who created the statute, okay, that we were talking to, that the town claims that we have violated, okay, had that statute been enacted sooner, we would be in a situation where they would have been required to go to the Department of Agriculture and have it examined so that they would determine whether or not it would be constitutional or not, or whether it could comply or not. And there's also a body of law in that statute that tells you what you can and cannot do when it comes to a farm. You can complain, and they will come down, and if the best management practices are being applied, then the ordinance can't be enforced.
And so what I'd like to do right now, if the other board members agree, is I'm going to give you, again, ample opportunity to respond. I'm going to turn some questions over and ask the CEO what he wants to say, but I just want to make sure I understand something before we do that.
Sure.
And again, I want to put on the record that after the CEO gets a chance to speak, we'll come back to you again, okay? Because
Sure.
you'll get to respond if you like. But we as a board are reading this timely filing of appeal. So you have 30 days. The letter of violation was October 30th. I think your appeal is dated November 28th. So you're filing it within the 30 days. And you're appealing this decision by the CEO, as you said, these two things he says, which is failure to give bills of lading. I don't think you said that out loud, but that's what we understand, right? Failure to give bills of lading and a failure to allow inspection of the site, or the
Correct.
premises, correct?
Correct.
So that's the appeal that you have. But I'm not hearing you make any arguments to us as to whether or not you did that. So I just want to put on the record, do you concede that bills of lading were not given?
Yes.
And do you concede that, I think it was in writing, correct me if I'm wrong, that the Livestock Corporation wrote a letter to the town saying, we're not going to give you permission to come and inspect?
Yes.
Okay. All right. So let's hear from the CEO.
Of course, it had a reasoning with it.
Right, I mean, I'm not saying that's all the letter said, it was actually a very long letter, and at the very end, I think it said that, so we'll let the letter speak for itself, but I just want to know if we read that right, that the bills of lading were not provided and there was no inspection permitted.
Yes, and can I say something that's really critical here?
Sure.
Understand something that we're not talking about trying to do something to the town or the planning board that's underhanded or behind their back or anything like that. We already have requirements that we send all of our bills of lading and whatever else we get. We don't get bills of lading from this stuff, but whatever it is that we get, we send to the DEP. Everything is sent to them, okay? Also, they have an inspection process that they come through and they inspect everything at all times. It isn't like what we told the town they couldn't do, but because of the fact that there was any problems with it or that it was a process we were trying to avoid. It's something that's already being accomplished and performed by the DEP.
And I'm speaking for myself as one sole member of this board. I don't have any power or vote greater than anybody else here. The very first time I ever heard about any of this stuff was when we got the appeal. When I heard that there was an appeal. So I didn't know anything about, I never even heard of the Boys Livestock Inc. I'm sorry, you guys, I didn't hear it, but I never did. I know my wife said she's heard of it, but I haven't heard of it. And nothing that I'm hearing from your presentation, which I think has been very professional, implies to me that any underhanded attempt has been made. So I appreciate you telling us that, but I don't think this board is sitting here thinking that the Livestock Inc. is trying to do something underhanded. I don't get that impression whatsoever. So I appreciate that you said that out loud.
Thank you.
All right, good. Jim, I don't know if Billy wants to present. Jim?
If I may, Mr. Chairman, members of the board, I'm Bill Dale, I'm a lawyer from Portland, I represent the code officer and the planner, with the code officer and the ordinance. In defending against this appeal, we provided a memo which lays out a position on the law. I was going to ask the code officer and the planner to go through some issues, but I think with a concession by the appellant that no, they're not complying with the two conditions, condition 7 and condition 9 of the conditional use permit. I'm not sure I need to do that unless the board wants to hear further. I think the code officer would simply say that no, they're not doing those two things. Mr. Fetter has conceded that point. With that, let me raise two legal issues. One, without question, this applicant has a conditional use permit from the town, has those two requirements, they're not complying with them. Our view is if they didn't like those conditions attached to their approval, when that approval was issued, they should have appealed them timely to Superior Court. There's a law court case right on point, as I said in a brief. Not only if you get a denial, you have to appeal it to court within a certain number of days. If you get an approval with conditions attached, if you don't like some of the conditions, you got to appeal it to court within a certain number of days, or you lose your right to challenge it. The second issue that I think the chairman raised, that I want to save for oral presentation here, is the presumption issue. I don't think it's permissible under Maine law for a municipal administrative board to make a determination about whether a statute is constitutional or not. The issue comes up all the time. Gee, this statute looks like it violates the federal constitution. This board is not authorized under Maine law or local ordinance to make that determination. Frequently in front of administrative boards there will be so-called equitable issues. Gee, we're violating the ordinance, but the code officer misled us, so we have a laches or equitable estoppel argument. Maine law is similarly clear. This board does not have the authority to make a determination over the relative merits of somebody's equitable offenses or equitable claims. And then the third point related to that is, to the extent, and we addressed this a little bit in the memo, does the Maine Agricultural Protection Act preclude the town of Arundel's zoning ordinance from applying here? I too spoke with this fellow's name, right? The Maine Department of Agriculture, who was, as you can imagine, delighted that he was a focal point of this appeal, with Mark Hedrick, who wrote this July 19, 2011 letter to Randy Du Bois, who simply, this letter does not constitute any get out of jail free card. If you read it, it simply says, yeah, it looks like you fall generally within our program. The statute is pretty clear that if the town of Arundel were to pass a new ordinance that seemed to preclude these folks from having this sort of facility, in order for such a new ordinance to be effective, you first have to send it up to the Commissioner of Agriculture and let him or her, for him currently, review it to make sure that it doesn't unreasonably interfere with the right to farm law and so forth. Here, of course, the town's ordinances all predate that statute. And so as I argued in my little memo, I can't believe that the proper interpretation of that statute is that that 2007 statute would require any municipality, whether it be Arundel or anybody else, to send up its year 2000 ordinance, enacted 7 years before the statute, to let the commissioner opine on whether that's permissible or not. Finally, Mr. Chairman and board members, I wanted to add, as I did in my memo, to the extent that Du Bois wants to argue, and I understand with some legitimacy, that the Maine DEP is largely all over this issue, of both their existing facility and their proposed expansion, which is not before you tonight. If they want to argue that, which I think we all understand that, with all due respect, they ought to go back to the planning board and say, you know what, the two amendments you put, two of the, whatever they were, 10 or 11 conditions you put in our conditional use approval, we don't like, for whatever reason, on the bills of lading and the inspections by the code officer and planner. We want you to change those, and for whatever reason, and maybe they're good reasons, we haven't really sort of gotten into the merits of that, but rather than ignoring the code officer, rather than ignoring their conditional use approval under ordinance that is not preempted by the statute, with all due respect, what they ought to be doing is going to the planning board and saying, look, we don't like those two conditions, happen to be number 7 and number 9, gee, planning board, won't you excuse us or amend them in such a way that somehow makes sense? And you know, if that happens, God bless everybody, perfect. But that hasn't happened. With all due respect, that's what they ought to be doing rather than ignoring the code office and the order from the code officer. So with that, Mr. Chairman, or please respond to any questions, but I would respectfully suggest the appeal ought to be denied, and what Du Bois ought to do if they're unhappy, if the appeal should be denied tonight, go to the planning board and say, look, here's what's happening in front of the DEP. They're all over us like white on rice, and we don't need to do some of these local things. And let the planning board decide whether that makes sense or not. With that, and please respond to any questions.
My only question right now, Lisa, is, and you kind of answered it at the end there, I know that you're arguing to us in your writing and your oral presentation that you believe the corporation had 30 days in which to appeal this conditional permit to the Superior Court, not to the Zoning Board of Appeals, correct? Yeah, your ordinance, the Arundel ordinance is kind of a funny provision, but the bottom line on it is if they wanted to appeal those conditions, those appeals were to go directly to court rather than to the Board of Appeals. my question, which I think you've answered, because I've had it for the last several days as I've been preparing for this hearing, and quite candidly, I even asked the town council, is if this board, no matter what this board decides, can this corporation still go back to the planning board and say, you know what, guys, I don't like these provisions?
Absolutely.
So they haven't lost any right to do that.
No, what they lost the right to do, under that court case I cited, happens to be my case, is they lost the right to go from the planning board directly to court and say, court, strike these down, this is wrong. What they haven't lost the right to do, which I indicated in my memo, is they can always go to the planning board and say, we want an amendment to our existing approval. And, you know, the planning board may give it to them or not. I think, with all due respect to the Du Bois, what they would argue is, the Maine DEP is all over us, requiring us to do a whole bunch of things. The public interest is protected, whether it's, and I gather odor, to a certain extent, odor may be a big issue. But maybe here it's some administrative issues with the bill of lading, which may be a pain in the neck and may or may not make sense for people in the biz. To make that application to the planning board to amend that, and that they have not lost the right to do. They can always do that. I obviously can't guarantee the planning board will, what it will say, but that's absolutely right. And it seems to me that's way better than ignoring what the code officer says and what the existing approval says, which is you got to do those two things.
Does anybody else have any questions for Mr. Dale? Thanks. So, you want
Yes,
to respond?
Yeah, we didn't get out of the jail card, and in relation to the permit, when we applied for the permit, we acquired a certain particular kind of permit based on the circumstances that existed for us at the time. Okay, we didn't know or have any inkling that we could make an application, okay, to the Department of Ag or the DEP, okay, for a status change, okay? So when we acquired the original permit, okay, we acquired it with the expectation, understanding that we were at that time a non-conforming use. Okay, we went out, okay, made an application, got everything that we needed to get from these other people, okay, and we're determined to be, okay, an agricultural type of an organization. So it was like getting an extra badge, something we didn't have back then. So when we got that, okay, it's not that we're trying to change the permit or avoid the permit. Okay, our contention is that the first permit and this and what we're doing with the composting now are two completely different things that don't walk together. We understand that when we got the original permit, okay, there was no way in the world, okay, we were a agricultural farming operation. We had to make an application to the Department of Agriculture. We had to send receipts showing what we did, that we were a farm, and actually prove it up. Okay, at that time, our status changed. Once our status changed, okay, we indicated that we did not ignore it, Jim. we indicated that we did not believe, okay, that we were composting under the license. Okay, and we weren't, because we were not composting under the license, which was based on our non-conforming status, okay, then we definitely needed to compost, as a farm. And it wasn't that we weren't letting Jim on because of that. We were saying, Jim, we're not acting under the permit. So therefore, if you're not doing anything under the permit, there's no need to inspect. And it wasn't an issue of whether or not he was there. It was the idea that, all of a sudden, we went through and made this application. It took us years to do this. It wasn't a day, okay? And they slapped a badge on us and said, you guys are an agricultural farming operation, which the letters say, okay? It's like, you guys are now this. Before that, we didn't have a chance to get it, okay? You have to go through a particular, process that transmutes you into this particular area, okay? Which was the reason that we did what we did. There's no going back to the planning board and saying, guys, we want to change the non-conforming farming use. The problem is we came to this other definition, okay, that put us in a different category for us to compost. It also made us a conforming use. We were conforming under the Agriculture Act before because of the non-conforming determination, we weren't acting under the Farm Act.
So just to kind of refocus, no, you're doing great. I just wanted to make sure I could refocus my own thoughts. So your position now is that the land use ordinance doesn't apply to you because you're essentially a solid waste facility now under the state statute.
Well, we're an agricultural composting operation. When you read section 410,
Yep.
there's only certain numbers of farming operations that fall into that, and it depends on the volume. Our volume pushes us into this particular thing where we're regulated very, very closely.
Okay. So are you a processing plant?
No, we're composting. You bring in the compost, you mix it, you put it on the pan, and it has to cook, and it goes through a whole, it's real good stuff.
So, okay. And so what's the relief you seek from the board tonight? What is it that you want us to do?
Well, what we'd like the board to do, okay, is make a determination that the citation that was issued against us, okay, is not valid based on the fact that we are in fact a farming operation, and we were not composting under the original permit.
Yep.
And if at one time we were, once we became this farming operation, okay, this particular permit just did not apply. Therefore, the issuance of the violation is not valid. And it's a very important issue for us because of the fact that, we were determined now to be a conforming use and back into a farm. Because, it's a terrible thing to be classified in the commercial area of solid waste. And there's something else I can say. We've also already been approached in relation to composting certain materials that would be commercial. At that time, if we took something like that on, the first people we would call is the town and let them know what's going on. We'd send them out here to inspect everything, okay, because we discovered there are certain types of fish products with things in them that would fall under this permit that we had before, which is a commercial form of permit as opposed to the farming. And it's not like we're trying to avoid the town of Runway. I mean, we spent months with these gentlemen trying to get everything within the shape. And when we got put in this particular new section of Farming Act, okay, we decided that the thing we had to do was to be under the act or not. I mean, to tell the DEP that we're acting in a non-conforming fashion will bring them right out. Okay, that's just how it works.
And not saying that you're done, but is there anybody else with you that wants to say anything or add anything tonight?
Explain A, B, C, what the D. Look at the types of waste, it's all,
Yeah.
everything we are.
The type of waste we're doing.
The only thing we're licensed to compost is agricultural waste. If you look at our DEP license, the only thing we are licensed to compost is agricultural product.
Otherwise, DEP would shut it down. If we would use that license, the town was given us,
If we'd be using a non-conforming use license,
the DEP would shut us down.
we have to comply. Our DEP license is only for agricultural use. It's the type 1C, it's all listed as agricultural products.
And just to make sure we have a clean record, you're Ricky, right?
I'm ready.
Randy, sorry. If we stay another 3 hours, I might get it right. And so you're Mark, right? You guys have any questions? Ladies, questions? Anything you want to respond to?
Just briefly, Mr. Chairman, with stating the obvious, this is the Board of Appeals under section 10.3A of the ordinance. You're here to decide whether there's an alleged error in the administration or enforcement of the zoning ordinance. That's what your authority is. I would add, as I indicated in the little memo I provided previously, that the Du Bois use under your zoning ordinance, which is the thing that you get to administer and opine on, is, as defined by your zoning ordinance, is they quote, solid waste facility, and as such, it is in this zoning district now a non-conforming use, which is a fancy zoning way of saying it's grandfathered. It's allowed to stay as is, it can't get bigger, but it's grandfathered. So they can't make it bigger. There may be an issue down the road about the proposed expansion. I guess we'll deal with that when that day comes. But it is absolutely a, quote, solid waste facility under your zoning ordinance. That's what you all get to regulate. It is comes specifically within the definition of your ordinance, and it is not allowed in that zoning district. So with that having been said, I will repeat what I did before. They have those two conditions on your ordinance. State law does not preclude local ordinances if they don't frustrate the purpose of state law. If the Du Bois are unhappy with those two conditions, which I confer they are, I think that their relief is to go to the planning board and ask for amendment. If they didn't like them and wanted them totally withdrawn, they should have appealed timely when they were first issued. And that's the law man. Thank you.
If they go back to the planning board and ask to have section 7 and section 9 amended in some manner because of the added scrutiny that they're now getting from the DEP, does that create a new appeal issue to the Superior Court?
I think absolutely. If they go to the planning board and ask for an amendment and the planning board wrongfully denies an amendment, I think that's an appealable within 30 days.
And that 30-day appeal, as John's asking, goes to the Superior Court.
Your ordinance is a little funky on this because it provides in the appeal section that certain things from the planning board go to the Board of Appeals and certain other things from the planning board go directly to court. The issue in front of you today goes direct. They should have, whatever it was 2 years ago, gone directly to court. I think it would be that same thing.
Okay.
So I think their amendment would. But yes, Mr. Webb, the answer is if they go and ask for an amendment and they are wrongfully, impermissibly turned down on an amendment, that's appealable.
Well, isn't it also appealable even if they're not, I mean, you're using the term wrongfully, but they can interpret that themselves, right?
Absolutely. They may decide that it's wrongfully, and some Superior Court judge may decide it was wrongfully, and some Superior Court judge might decide it was permissibly. Within the discretion, what I'm saying, I'm sure the boys understand this, some things you go to administrative board are clearly right and clearly wrong, and some things are in the gray area, and the Superior Court judge sometimes will say on review, gosh, if I'd been on the administrative board, I probably would have voted the other way, but I can't say that what the administrative board did was clearly wrong, so I'm going to uphold it. So that's sort of a yes, no, and maybe proposition. But absolutely, if they go ask for the amendment, or amendments to conditions 7 and 9, the planning board might grant it, great, end of story. If it doesn't, they can decide what they want to do, including the possibility of appealing. That would resuscitate an appeal.
Good. Okay. Thank you. Any other questions of anyone? So do you have anything else without repeating your position? I just want to really make sure your side here feels that you've had adequate opportunity to tell us what you want to tell us.
Yeah, I just understand that, you know, what we're seeking from this appeal board is the ability to remain a farming operation, okay? You know, that's not hindered by the CEO. I mean, not only hindered in a bad way, but you know, it's something that you know, we're not just seeking to change a couple of the issues of having somebody come and inspect. Our concern is the fact that we have a new and different, you know, status, and that particular status creates a character of our business, okay, that makes us exempt from this particular ordinance.
Got it. Thank you very much.
Thank you.
And before we start, and we're going to deliberate right here in front of you, but at least me, I really appreciate how professional you've been, how comprehensive you've been, how polite you've been. Quite candidly, I think you give a pretty compelling argument. But as you're going to hear from me in a moment, I don't think we have jurisdiction here to do what you want us to do. I mean, again, just one vote. But I really, I'm not saying your presentation hasn't been equally persuasive, but I just want you to know that I would
Sort of.
I mean, when I get this stack of stuff, quite candidly, gentlemen, you know, sometimes when you first see it, it becomes overwhelming. You say, oh, okay, I've got to pour all these statutes, and how are you going to put this together in front of us when we get here? And you did it in a pretty cool way, so thank you for that. So we're going to start talking very openly. You guys have heard me say it now a couple times, and I actually opened up to it. 10.3A, 10.3.A tells us it's entitled our powers and duties as a board. And clearly it says in black and white, the hearing decide appeals where there's a zoning violation or we believe there's an error by the code enforcement officer with respect to the decision he or she's made. So I don't think we have preemption power. I'm pretty confident about that. There's been no citing of any law or statute that says that we do. The candor of the applicants is that they didn't comply with 7 and 9 or even 8.10 of the land use ordinance. I actually think, no matter how compelling it is, our hands are tied. We have to adhere to the only powers that we have. And I'm happy that we have the right to go back to the planning board and ask for a amendment. Anybody get any other thoughts about that?
I agree on those ones, I guess it's beyond that one.
Do you have any thoughts?
No, I thought that was my first concern once I got through everything.
That they do have an avenue.
Yeah, but and that we don't have the authority as the body that we are to do what Saul and the Du Bois want to do. And I thought, Saul, you did a great job.
Thanks.
But,
Yeah.
and I totally get what he's trying to say.
And in all fairness to Jim too, I mean, I don't want to sound, I mean, there's a planning board puts out this conditional use approval, and Jim, as a code enforcement officer, is complying with what that says. He's doing what he's supposed to do. He's not here, he doesn't have the power, just like we don't have the power to say, you know what, that's unfair. We don't have the power to say that, or we're gonna preempt. And Jim doesn't have that authority. His authority is to be just what his title is. He is supposed to enforce the ordinance. And so, and sometimes when I hear these things, I wish we had more power than we do. Sometimes I'm real happy that we don't. Yeah, I just don't think we do. So, anybody want to make a motion?
Can I just ask a point of
Yeah,
clarification,
sure.
if I may? As you know, findings have to be clear.
Right.
And so I heard a couple of things. I hear you saying that you don't have the jurisdiction to make this decision. I heard it once mentioned that you don't have the jurisdiction perhaps because there was appeal period back when, 30 days, when the original I think there's the original conditional use permit, but then every 3 years they had to be renewed. I think the most recent was February 24, 2011. Is the argument that you don't have jurisdiction because there was an appeal that should have been taken and it wasn't, therefore you don't have jurisdiction, or because you don't have the jurisdiction to deal with preemption issues, or both? I just want to make sure that's clear.
From my perspective, we absolutely have the jurisdiction to hear this appeal. Meaning, we can hear the appeal as to whether or not the amendments under 7 and 9 have been met or not or violated, and whether 8.10 has been met or violated. We have that. With the candor of the appellants, they've conceded they haven't met those. I think we have the absolute authority to hear that. Do we have the authority to hear an argument? We can hear it. Do we have the authority to decide? We heard it. We gave the respect to hear it. Do we have the power and authority to decide a preemption argument? No. This board doesn't have that power or authority. Whether that appeal was made within 30 days to the Superior Court or not, I still don't think that matters as to whether we have preemption power. We don't have preemption power as the zoning board of appeals in the town of Arundel. There's no ordinance or statute that gives us that power. You guys agree on that?
I agree.
I keep saying guys, I apologize. Okay. So, any other point of? Okay.
So if you want me to second that as the motion,
No.
I'd be happy to do it.
All right, second is the motion. All in favor of that? So then, because of that, we should vote on this appeal. So the appeal as presented. So I need a motion on that as well. As to whether the appeal's denied or.
So I move that the appeal that was timely and properly filed by Du Bois Livestock should be for the reasons of the previous motion denied.
Second? Second. All in favor? All right, gentlemen, so you understand that, Saul?
Yes.
Okay, and again, thank you, both sides, for really presenting this. And the planning board members that came before you, thank you for coming. So, just to save those all, 30 days to do something with this?
You want me to go to someone?
Yeah. So what we're gonna do is, we're gonna solve, just, we're gonna have findings of fact from this hearing, they're gonna be drafted by the town's attorney, and then we're gonna come back.
And
review them, and then after we kind of so order it, then they have an appeal period for this?
Well, that's, let me just make sure, because
Yeah.
there's some big law about if it runs from the date of the decision or the date of the written,
Yeah, that's what I want to make sure they know what
Yeah.
they have to do when they have to do it.
yeah. For subdivision, it is for, planning board decision is from the date of written. But I think at this point, and Bill, please chime in if you think I'm wrong here, when it comes to a board of appeals, I think you have 30 days from the date of the decision. You have a decision, and probably to be safe, that you want to run from that.
And so that's my interpretation as well. So today is January 10th. Today's the decision. So to really be safe, if you don't want, your discretion, you don't want to go to the planning board and do what we've been talking about, we're certainly not telling you to do that. We don't have the power to tell you to do that. If you want to somehow take some action against this decision, start the clock today, 30 days from today to be safe. Good.
We just don't want you to miss your appeal period, that's all. Because the Superior Court will be unforgiving. Trust me.
All right, thanks. So, you guys can stay, we just have other matters, it's up to you, but, so we gotta discuss, before we leave, when we can meet again as a board to go over the financials. Okay? We should try to do it within the next 3 weeks. What do you think?
Then I feel like that's right.
That's what they just said. I don't want to put my schedule, I travel golf. There was a time we were long before I mentioned
I think they
we were meeting all the time for variances mostly. And all of a sudden, 2008 hits, right? And we kind of kind of slow sometimes. Even then, like 2009, 2007, we might have got 2 a year. And then we had some bigger things.
fine. The boys can argue that, you guys can decide how this, that's what the ordinance doesn't particularly say.
We did that under a condition.
Yeah, I think the ordinance doesn't.
Interestingly enough, my
So guys, can we just
They no longer fit the class.
So let's pick a date, maybe right now.
Permit.
We go back to 2000.
They want to say then, say, well, there's something different.
31st, you're not meeting on the 31st,
I would
right?
have your ordinance.
You need to go take your petition.
You can't get this from?
I don't think that.
You gotta tell me you're working out.
What your ordinance says,
They come here.
that doesn't say
It's
about
probably missing.
conditions. Your ordinance talks about then they want to change the report, what they thought and what they done.
Right, right.
But I wasn't going to
But
do
the
that.
problem is, all of this is
And then you look at the code of the inspection, I think you've also said the code of planning act. There may be a personality.
Yeah, the 31st
Like ads right now, but they have a bunch of them.
kicked us out.
My direction that is,
So they kicked us
you
out. So
might
you
make
go
this
to the
code
CEO office?
under main law.
Although that's kind of, that's
Your
kind
Still a
code
public
of
agency.
planning
of.
direction.
It's not.
That may be a personality issue, side act,
So on their first stuff.
That's what make that go away.
They're available.
Clearly, the code
It's
of.
available on the site.
He can go over there, he can go tomorrow with a court order.
Check.
You check with
They had to
me.
give up.
She just
My
told me,
sense is it may be a
this afternoon,
Personality.
late this afternoon that we did.
pad.
We're gonna do this over there. I mean, we're going to. ZBA could go to this firehouse.
If their personality, if their personality.
So we're not agreeing on a date right now, I'm sure you.
I don't
We're on traveling.
I don't care if things are pain like not, really, the state law and local law is the guy. Yeah, there's a kind of involved, but
Yes,
it'll be state law and local law, he's not really the guy.
Well, works
It's
is
not a pain in the ass, they don't want to.
So what is it gonna be to
Make trouble.
just
You
to
can't
go
do that.
findings
Yeah,
and
that's
agree on it?
Local law.
I'm gonna see if we
No, I
can
like
get
that.
this room. I will let you know, I'll confirm it tomorrow.
I'm getting back to that.
Do you want to, do you want to?
Where do
do
they
2
go
weeks, or
if
do you
they
want to
want
do
to
it?
They just ask the county, ask the county, change the ordinance.
To the town meeting, not to the planning.
Oh, no.
They can make it look like planning board. There's a couple of
Bring it to the planning board to change the ordinance, or they can petition to the town.
But ultimately, it's gonna be that, it's gonna be
I'm
county,
very open.
people are raise their hands and change their use.
And how about the week before, is anybody?
The only other recourse,
For what that tax.
the only other recourse if they wanted to go to court, if they were so inclined to go to
So,
court.
I'm
You
going
guys
to
come.
the
The one day I can do that week is
That they don't apply,
I'm
that we have no authority over them,
That's exactly 2 weeks.
and therefore.
What's the date?
With
The
the,
24th, it's a Thursday?
or that we.
Well, but that's what I
Is
was
that,
thinking in terms of.
well, I'm just trying to come up with
reclassification.
dates.
It wouldn't apply because
I
I
can
think
see
they're
what
classified as.
Well, they
As
did
for availability.
They wanna have
But,
times people.
I can
and
check,
zoning.
if you're open on the
Pretty fine.
John, I
Right,
can
I'm
check the
using it within
24th or the 30th,
every
and get back
night,
to you
sometimes people do
tomorrow,
that.
let you
Fine.
know.
But it's not you guys, and it's not him, it's not Tad, it's not the Board of Appeals, that's town vote.
And
You
if
may
we
change
have
it,
to
but you let us
leave,
know.
we have to leave
Yeah, the
at
whole
6
written-
o'clock, will you,
Well,
be
I
able to
say
meet
it
at 6?
verbally that.
I love that excuse to get out of my office early. You kidding me? Let's do it.
On both days.
We'll go after this.
Everybody,
You know,
everybody needs to
whatever
understand about
works,
it.
I mean,
The most
like I said, I don't know when this, what's
This is one
available,
shoe.
but
Next
if the
shoe
planning
is about
board
to
is
go.
meeting
They
on
want
the
to go from
24th at
9,000
7, if we come in at 6,
to the Jason pad.
I didn't know, so I can just.
I'd have a little problem with that on
Use
January
is
30th to make it here by
grandfather
6
not
from
conforming, they keep it like that, they can't do
We
it.
could
Be like a little late, I can make
That's the
it,
thing,
Yeah.
that's fine.
but
Yeah, no, we gotta be able to do it at 7 on the 30th.
I don't have any problem on the.
I'll stay around,
Especially when you're the one.
but I'll just get in touch with you all tomorrow, and, I'll send you an email with
Yes, 24th is and 6 will work for me.
Being the chairman,
We said the 24th at 6 o'clock.
Yeah, I'm gonna check to see if it's available.
gracious, and one of his public things, they can
That's
calm
our-
down.
Because of the 19th. They need a new application.
I gotta do something.
And your help is really great. Yeah, so I need to adjourn. Norm's adjourning. All in favor? Boom. We are adjourned.
What they do is that I